to begin this process...
Judge, did you want to swear them first?
Yeah, I'm getting there.
Okay, thank you.
Hold on a minute. In order to begin this process, now that I have a jury picked, it is required that you take an additional oath. So if you would stand and raise your right hand, please.
Do each of you solemnly swear or affirm that you will fairly try the issues in this case according to the evidence and the instructions from the court?
Yes. Thank you. Please be seated. The procedure that we will follow during this trial is as such. First, the prosecuting attorney may make an opening statement outlining the testimony of witnesses or other evidence that he expects to be presented during the trial. The defense attorney may then make an opening statement or may choose to make an opening statement at a later time. Next, the prosecuting attorney will present the testimony of witnesses or other evidence to you. When the prosecuting attorney has finished, the defense may, but need not, present the testimony of witnesses or other evidence. Each witness who testifies may be cross-examined by the lawyer for the other side. Next, when all of the evidence has been presented to you, I will instruct you on what law applies to this case. I will read the instructions to you, and you will have individual copies of the written instructions with you in the jury room during your deliberations. After I read you the instructions, the lawyers will then make closing arguments to you. Finally, you will be taken to the jury room by my law clerk, where you will select a presiding juror. The presiding juror will preside over your discussions of the case. These discussions are called deliberations. You will then deliberate in order to reach a decision, and this decision is called a verdict. Until you are in the jury room for your deliberations, you must not discuss this case with the other jurors or with anyone else, or remain within hearing of anyone discussing them. It is your duty as a jury to decide the facts in this case based upon the evidence presented to you during this trial. Now, evidence is a legal term. Evidence includes the testimony of witnesses. It also includes documents and other physical objects. It is also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you think it ought to be. You are to apply the law from my instructions to the facts, and in this way decide the case. The only evidence that you are to consider consists of the testimony of the witnesses and the exhibits admitted into evidence. When witnesses testify, please listen carefully. You will need to remember testimony during your deliberations because testimony will rarely, if ever, be repeated for you. Any exhibits admitted into evidence will go to the jury room with you during your deliberations. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and to apply the law. However, the lawyer's statements are not evidence or the law. The evidence is again the testimony of the witnesses and the exhibits. The law is contained in my instructions to you. You must disregard anything the lawyers say that is at odds with the evidence or the law in my instructions. You may hear objections made by the lawyers during trial. Each party has a right to object to questions asked by another lawyer, and in fact they may have a duty to do so. These objections should not influence you. Please do not make any assumptions or draw any conclusions based on a lawyer's objections. One of my duties as a judge is to decide whether or not evidence should be admitted during this trial. What this means is that I must decide whether or not you should consider evidence offered by the parties. For example, if a party offers a photograph as an exhibit, I will decide whether it is admissible. Please do not be concerned about the reasons for my rulings. You must not consider or discuss any evidence that evaluate the evidence, it would be improper for me to express, by words or conduct, my personal opinion about the value of a particular witness's testimony or exhibit. I will not intentionally do this. However, if it appears to you that I have indicated in any way my personal opinion concerning any evidence, you must disregard this entirely. You have met my law clerk, Sarah. You will be in her care throughout this trial. She will help you with any problems you may have related to your jury service. Do not, however, ask her anything about the facts or the law in this case. Please follow any instructions that she gives you, as those instructions come directly from me. I will not have any personal interaction with you other than that which occurs in this courtroom. So treat Sarah as if the court is speaking to you. You will be allowed to take notes during this trial. In fact, we have handed out notepads with your juror number on them. They are either in your lap or you're sitting on them. Whether or not you take notes is entirely your own decision. If you choose to take notes, you should make sure that it does not interfere with your ability to listen and to observe the witnesses. You must take notes on this pad only and not on any other paper. You must not take your notepad from the courtroom or jury room for any reason. When you recess during the trial, please take your notepads with you to the jury room. At the end of the day, the notepads must be left in the jury room. And while you are away from the courtroom or the jury room, no one will have access to your notes. No one will read your notes. They will be secured in the jury room. You must not discuss your notes with anyone or show your notes to anyone until you begin deliberating on your verdict. This includes your fellow jurors. During deliberations, you may discuss your notes with the other jurors or show your notes to them if you wish. You should not assume, however, that your notes are necessarily more accurate than your memory. I am allowing you to take notes to assist you in remembering clearly, not to substitute for your memory. You should also not assume that your notes are more accurate than the memory or notes of the other jurors. After you have reached your verdict, your notes will be collected by Sarah, and they will be destroyed. No one will have access to them. No one will read them. Throughout this trial, you must come and go directly from this jury room. Do not remain in the hall or the courtroom, as witnesses and parties may not recognize you as a juror, and you may accidentally overhear some discussion about this case. As I told you yesterday, I have instructed the lawyers, the party, and the witnesses not to talk to you during this trial. It is essential to a fair trial that everything you learn about this case comes to you in this courtroom and only in this courtroom. You must not allow yourselves to be exposed to any outside information about this case. Do not permit anyone to discuss or comment about it in your presence. You must keep your mind free from outside influences so that your decisions will be based entirely on the evidence presented during this trial and on my instructions to you about the law. Until you are dismissed at the end of this trial, you must avoid outside sources such as newspapers, magazines, the internet, radio, or television broadcasts, which may discuss this case or issues involved in this trial. By giving this instruction, I do not mean to suggest that this particular case is newsworthy. I give this instruction in every case. During this trial, Please do not try to determine on your own what the law is. Do not seek out any evidence on your own. Do not consult any reference materials, such as dictionaries and the like. Do not inspect the scene of any event involved in this case. And if your ordinary travel will result in passing or seeing the location of any event involved in this case, do not stop and try to investigate. Throughout this trial, you must maintain an open mind. You must not form any firm and fixed opinion about any issue in this case until the entire case has been submitted to you for your deliberations. You may have noticed that we have media present in this courtroom. I have instructed the media that they are not to interrupt the proceedings, and they're not to take pictures of the jurors, but they have a right to be in the courtroom. I do not know if this media will be broadcast in the evening, but you should be careful about what TV you watch or what internet sources you go to during the course of this trial. It's best just to leave all that alone until this case has been submitted to you for your deliberations. I'm going to allow you, some judges don't, but I do, to keep your electronic devices during this trial. Make sure that they're off, number one. Number two, make sure that you don't do any research, as I indicated to you. It is not fair to anybody if you folks are accessing information outside of what is presented to you in this courtroom. We have no ability to filter what you see. We have no ability to determine if what you're seeing is true or not. And contrary to popular belief, not everything on the internet is 100% accurate. And so it's important that any information about this case come to you here in this courtroom, where everybody has an equal opportunity to test its veracity. If during breaks you wish to use your devices to contact work and whatnot, to check up on people, I'm going to allow you to do that. I'm going to rely upon your oaths as officers of this court not to talk about this case, discuss this case, or seek out any outside information. I've asked you to come and go directly from this courtroom to the jury room. And in the morning, please don't hang out in the hallway or anywhere else. Just gather here. We'll get these doors open so that you can walk through and get back into the jury room. That's where I need you to be. If you're hanging out in the hallway, then I'm going to have you guys report downstairs to the jury coordination room. But I'd rather you just come through here. So if there's any difficulties, let Sarah know about that, okay? You have water there on each level, so somebody's going to have to be in charge of that. You're free to drink your water and whatnot in the courtroom. I'm not a real stickler for that, but you have to ask each other. We typically start at 9 o'clock. We end our day at 4:30. We have a 1-hour lunch break from noon to 1. We also have a mid-morning break, about 10 minutes, 15 minutes, and a mid-afternoon break. Generally, that's how our days will go. As I indicated to you folks during the process yesterday, Fridays we are taking off. I have obligations as the Snohomish County Adult Drug Court judge that takes my responsibilities all day on Friday. So Fridays you will have off. You don't need to report here. You go to work or stay home or whatever. Okay, so I'll talk to you more about that as we break on Thursday about Friday. As jurors, I will remind you that you are now officers of this court. And as such, you must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference, and to assure that all parties receive a fair trial. You must act impartially and with an earnest desire to to reach a just and proper verdict. Those things conclude my remarks to you. We now move into the phase of opening statements by the parties. If you wish to take notes during opening statements, you're free to do so. But please make a demarcation in your notebook that these are opening statements, separate and distinct from the evidence portion of the trial. With that, folks, if you'll give your attention first to Mr. Stroll.
Thank you, Your Honor. May it please the court, and may it please you, ladies and gentlemen. Welcome. This is what Brenda Welsh looked like a little before 7 o'clock on November 16, 2014. And this is what she looked like a few hours later. What took Brenda from that to that is that man, the defendant. What caused Brenda to go from blonde to burned and from beautiful to beaten was this man's anger and disdain and greed. Let me start with a little background about who these folks are and how they met each other. In the early 2000s, Mr. Morgan and Brenda were married to other people. The defendant was married to a woman named Laura, and they had together a child, a little boy named Ryan, early days. Brenda was married to a fellow named Kirk, and they would together have 2 little girls. The defendant worked, as he did through the date of this event, at Bone. Laura also worked. Brenda generally worked around children, daycares and whatnot. She was the type of person people entrusted their children to, which is precisely what Mr. Morgan did. He had hired Brenda, met her and hired her to be a nanny for his young boy, Ryan. And what would happen is that Brenda would leave her home and drive to his. He would go off to work, Laura would go off to work, and Brenda, the defendant entrusted with his child in his home, would stay in the house and take care of Ryan. Her oldest daughter was roughly the same age as Ryan at the time, and she would come with Brenda as well. 2 children would spend some time together. And all day, that was her job. By about 2005, both of their respective marriages dissolved. And Brenda, at that point, 11 years younger than the defendant, began to be courted by Mr. Morgan. Mr. Morgan, Brenda was still in, she had a place to live. Mr. Morgan, when he was separated from Laura, lost his place to live. He needed a place to live. He was tossed. And the defendant moved into Brenda's home in Lynnwood, the same house that the events took place in this case. They lived in Lynnwood, here in Snohomish County, Washington. And Ryan also would spend time there. As he sort of courted her, they developed a relationship. And by November of 2006, Brenda was pregnant. In December 19th, 2006, the defendant in chief flew off to Hawaii, where on the 19th of December, they got married. 7.5 months later, little Kylie was born. Beautiful little girl born. And Kylie and Brenda, the defendant and Ryan, lived in this house in Lynnwood. Shortly after the marriage, Brenda began to realize, boy, I've made a mistake. Things got bad quickly. And Brenda was in that situation, she'll tell you a little bit about, where she had just had a young child. She had recently gotten divorced, and whatever thought she had about a rebound marriage and what that did. And she had this young child who she adored. So she tried for a while to see if she could just make it work. Maybe the things would work out. But things got bad. And the house that she had lived in, the house that she brought the marriage into, began to change. The defendant and his son took over large parts of the house, and she ended up living in a smaller part of the house. They did not share a bedroom. They were living sort of separate lives. Now, we're not going to be talking about details of divorce. That was long ago. So we're not going to get into that. Suffice to say, they lived apart, and things weren't good. It was no longer a comfortable place for her. By the time, after about 6 years of this marriage, by the time Kylie was basically old enough to go to school, Brenda said, that's enough, she's going to school, and she filed for divorce. Brenda moved out of her own house, the house that she had brought into the marriage. And she moved out, she will tell you, because it no longer felt like her house. She no longer felt nested or comfortable or safe being there. So she left. The house, during the course of the divorce, she just gave to the defendant, deeded it over, became his interest, his insurable interest. And as the divorce proceeded, it took about a year to proceed, there weren't a whole lot of assets and whatnot. They had the house. He had, in essence, in her terms, ruined it for him. He gave it to her. I gave it to him. And she also felt, well, listen, well, she wasn't comfortable there. It still was the house Kylie had grown up in. And she'll didn't have that attraction to the house. And she wanted Kylie to have a place that was familiar to her, even if it was uncomfortable for her. So as part of the divorce, she just gave him the house. Now, the defendant, as I said, was working a bone. And in the years leading up to the divorce, he was making $125,000, $130,000, $137,000 a year. More than 4 times her income. And so when it came time to divide whatever obligations there were, the defendant already had a fair amount, over $30,000 in debt. But there were 3 main things that were able to be divided. He worked at Boeing. I think 1 or 2 of you may work there. Boeing has, at least by contemporary standards, a nice little pension program. And they've got sort of 2 types of programs. One is a traditional pension, where if you work long enough, you get some certain benefit in the end. The other is a type of a deferred compensation. You can pay in, and theoretically grows like a 401k type of program. Washington State is a community property state, and you'll hear Brenda's lawyer. You will hear Brenda's lawyer, Laura, explain some of this to you. But because it's a community property state, Brenda had certain rights for certain parts of those funds. Not all of it, you don't divide it in half, but sort of 1/2 of what was acquired during the time of the marriage. And since he'd been married before, and since they'd only been together for a while, it's a bit of a complicated mathematical formula. And as you imagine, there's one particular person who became an expert on that. That's a lawyer down in Portland who got involved. But what it turned out to is there were three things that are sort of relevant to what we're talking about. The defendant had an obligation to pay Brenda, and by the way, by this point, they didn't like each other too much, $37,500 from his pension. Out of the deferred comp, he had to pay 50% of a certain amount, again, in the tens of thousands of dollars. And remember, he was earning about $6,500 a month at that point in time, according to the documents. And he was required to pay her, and she of course, by the way, became the custodial parent of Kylie. She would keep Kylie. We'll talk about that in a minute. Kylie would live with her most of the time. And he would pay some bit of child support. Out of his $6,500 a month of income, he was asked to pay $1,000 a month. Now, Brenda, pretty reasonable, as you'll hear, because the defendant, right around this period of time, had hurt his back. And because he had hurt his back, he was off work for a period of time. And so Brenda said, listen, that $1,000 a month, they wrote this into the settlement, the divorce.
I'm sorry. I didn't hear
They wrote this into the divorce. Listen, if you're not working because you're hurt, just give me $200 a month. When you go back to work, that'll go back to the $1,000, and since you'll be $800 a month shy, just add in $500 a month, so it'll go to $1,500 until those arrears are paid. Make sense? So you owe $1,000, you only have to pay $2. When you go back to work, that $2 is going to go up to $1,500 until you make good. $1,500 a month. In the middle of December 2016, two things happened. The defendant was going back to work. That income was going back from $200 out to $1,500 out. And on the 12th of December is when that lawyer from Portland, who was figuring out how much do you owe, sent him a letter saying, hey, it's all done, sign the papers, you owe this much money. Now, if Brenda died, the pension money still had to get paid out, but it would just go to their heirs, which would generally be Kylie. But if Brenda died, that $1,500 a month disappears. That payment to her for that deferred comp disappears. If those die, so does that obligation. And he learned about that the week before that happened to Brenda. Now, Kylie, of course, ended up living with Brenda. And the defendant had obviously some visitation rights. And one of the things that they worked out was for weekends that the defendant would pick Kylie up after school around 3 o'clock on Fridays, 3 of the 4 Fridays a month, so 3 Fridays a month. Pick her up, and at 7 o'clock every Sunday, Brenda would drive to that house and pick Kylie up. Every Sunday, 7 o'clock, every Sunday, 7 o'clock, on the button, she was there. When she'd go to pick Kylie up at the house, remember, she had left that house. She didn't like that house. He had changed the locks as soon as she moved out. She never had a key, and she never went inside the house. She didn't want to go inside the house. When I say inside the house, there were some times that she'd take one step into the foyer to pick up her items, a backpack or whatnot. She had done that a time or two. When the defendant had opened up the door, she may take a step in just to pick up stuff on the floor, but she never entered the house. Never wanted to enter the house. Never was comfortable in that house. Never was safe in that house. And that, indeed, was the plan on Sunday, November 16, 2014. Because that was a Sunday. That was the day she was going to go pick up Kylie. And as she had often done, she reminded the defendant of this obligation, and around 3:30 or so, 3:36 I think it was, she sent the defendant a text message on that Sunday. Hey, make sure you have Kylie ready to go at 7. I'll be there at 7. She, at that time, was now living in Lake Stevens. She was living with a fellow named Chris Anderson. And Chris Anderson's parents, hey, that day was their 51st wedding anniversary. They were over at the house. And the Andersons knew Brenda, and they knew the routine, and they knew that she always went over, leaving around 6:30. And they will tell you, because they were asked later on that day the specific time, so they may know, that at 6:25, she left that house in Lake Stevens, heading to pick Kylie up in Lynnwood, where she was supposed to be. She left at 6:25 from Lake Stevens. At 7:10 that evening, Lynnwood firefighters responded to that house because it was on fire. And about 10 minutes later, Scott Russell, a firefighter, pulled Brenda's bloody, beaten, burned body out of the garage. She had what he and others will describe as agonal breathing. Very hard time breathing, like a fish out of the water, he'll describe it. And when they tried to save her life and get her into the ambulance that would eventually rush her to the hospital in that closed environment, the firefighters noticed she smelled strongly of gasoline, as if gas had been poured over her. Brenda's nose was broken, as if she'd been punched in the face. Brenda, well, let me show you a couple of photos. Recognize they're not pretty, but I need to show them to you. Brenda had skull fractures on the right back of her right skull. Skull fractured terrifically. And she had maybe a little hardness light, you'll see it better, 2 long lacerations, parallel lacerations on her head. And if it's easier to see in this photo, these 2 long lacerations inside her head, parallel. Her skull fractured. Her body burned. Her shirt burned off, and her body burned. The only areas protected were the areas where her brow was. Burns over 20% of her body. She sustained other injuries. She lost hearing in one ear. She lost her sense of smell. And when your skull is fractured, if it hit with enough force, the head is designed, the doctors will tell you, you'll hear a couple of doctors from her review come tell you, the head's designed to protect yourself. So if you whack yourself against a door frame or fall down, you do okay. And there is not only the skull, which is pretty heavy, but there are various layers of protection called the dura, D-U-R-A. If you're hit with enough force, you can cause bleeding. And the more force, the deeper that bleeding becomes, and the deepest is something called the subdura, underneath the dura, subdural hematoma. She had it, bleeding deep in the brain. And she was hit with enough force that what makes the brain sort of work are these things called axons. And when you hit with enough force and there's enough blood, some of those axons can settle, and they can do some damage to you. Did some damage to her. The damage it did, and she'll tell you, is those burns you saw, they are her only permanent memory of what happened to her. Because when the axons were sheared, she lost her memory of what happened that night. She does not recall that night. She only recalls waking up in the hospital. So there will be times in her trial, and during her testimony, that she will be able to tell you, I don't know, or I can't remember. And every time she tells you that, remember, that's one more thing he took from her. As she was being rushed to hospital, where the doctors and the paramedics were trying to save her life, Harborview, where she would spend well over 6 weeks, police and investigators learned a bunch of things. They'll share with you. I'm going to share about 3 of them with you now. They learned that the fire in the house appeared to be deliberately set. Now let me explain to you, as the fire marshal will, so you understand how a fire investigation goes. Arson is particularly complicated when you think about it. The evidence, A, burns up, and B, when the firefighters come with their hoses, what isn't burned up is often washed away. It becomes a little complicated. So what the trained firefighters do is they look at everything that could possibly go wrong. For those of you familiar with medicine, it's like a form of differential diagnosis. You figure out what you got because you've eliminated everything else. And that's what the fire marshal did. Exhaustive investigation, looked at everything. There is no accidental cause. Not electrical, not, all the things that they see. Nothing. The only thing we can't eliminate is arson. And, she smelled of gas. She burned. There was, as you'll hear, gasoline on her filter. We eliminate everything. Arson is consistent with the evidence and the only thing that's left. You'll also hear that he was found right on the scene. The defendant's found on the scene, utterly unhurt. Now, you'll hear that he claimed to have a whole bunch of injuries. These paramedics say, couldn't find anything. He's complaining about stuff. They were inconsistent with what we saw. They're inconsistent with anything we've ever seen. We've never seen anyone act like that. They will tell you that what he did in his conduct didn't help anything, did not seem to be responsive, and only appeared to be a delaying tactic to delay the putting out of the fire or to find Brenda as she lay dying in the garage, which, by the way, itself was unburned. Unburned. That delay, just his actions just proclaimed delay. And he would tell some stories, offer some words that would, over time, be inconsistent with each other, which would, over time, prove to be inconsistent with the facts, and prove, over time, to be inconsistent with logic. And Kylie. Kylie was safe. Kylie was safe because Kylie wasn't there. The defendant had earlier that day taken his daughter to her grandma's house, something he didn't typically do on Sunday However, her clothing, her stuffed animals, and a whole variety of family keepsakes, photo albums, tax returns, pictures, wedding albums, the types of things you might gather up if your house is going to burn, they were all in his car, which had just been recently filled with gas, ready to go. What changed Brenda from that to this was caused by a man with motive, with means, with opportunity, driven by greed and driven by disdain and driven by a desire to try to alter his life by trying to end hers. Thank you for your time.
Ladies and gentlemen, if you'll give your attention now, please, to Mr. Wagner.
May it please the court, counsel, David. Ladies and gentlemen, the state has just told you a story, an emotionally affecting story, a story assisted by dramatic and awful photographs. But a story, if you listen carefully, not to what the prosecutor says, not to what I say, but to the evidence as it comes from the witnesses on cross-examination as well as direct examination. If you resist the state's appeal to sympathy and emotion and judge the case on the facts that are elicited over these next days, if you do that, you realize that story falls short of any sort of proof in this case. You'll hear information about the relationship between Mr. Morgan and Ms. Welch, how they came to be a couple, how they came to be divorced, how they had worked out the circumstances of their divorce and their custody of their common child, Kylie. And the state talks about, well, financial motive, $37,500. And you'll hear from the lawyers, it was paid in full. The money was paid. The only difference was there was money that had to be brought current because of the fact that Mr. Morgan had sustained a serious injury at work and was not able to earn his full income. But his obligation to his child throughout was maintained. His obligations under the agreement to Brenda were paid. Listen carefully to what the witnesses actually said, not how it's characterized, not to appeals, to emotion. Listen to what they say and you realize there is no financial motive for this crime. Now, clearly, that woman is horribly injured. Something happened to her at that house. And perhaps the greatest tragedy for Mr. Morgan is the person who could clear him has no memory. And the reason I tell you to listen carefully to what the witnesses say and not what the attorneys said. When Mr. Hardesty, the fire marshal, gets up to testify, what he will tell you is that the exact cause of the fire is undetermined. He cannot determine what caused the fire. He cannot tell you that this was arson. What he can say is an intentional fire cannot be excluded. He can't rule it out. And in part, what becomes telling is observations of some of the fire personnel who were on scene. Firefighter EMT Melissa Beard will talk about problems in putting out the fire. That water would be applied and it would appear in the great room, in the back of the house, not the garage, where it would appear that the fire may have originated, was a room under construction. The officers will tell you that the house appeared to go up quickly because there was no sheetrock in the large room. The wood was exposed. There were cabinets apart in the kitchen. The room itself was being remodeled. There were some, whether it be painting supplies or other supplies, in there. Could those act as an accelerant? Could those cause the reaction that firefighter Melissa Beard sees? But they don't say what the source of the fire was. And the fire marshal, the arson investigator, can't say what the source of the fire was. And he cannot say, and will not say, that it was caused by arson. What he will say is, we don't know what caused it. We can't rule it out. And I haven't been able to come up with another explanation, with any explanation whatsoever. Now the state may say, for them that's good enough to call it arson. But listen carefully. And as you listen, hold in mind the fact that Mr. Morgan is presumed innocent. And the state has the burden of proof beyond a reasonable doubt for each of these allegations. When you hear the state's claim that all that Mr. Morgan did was endeavor to delay and stop the firefighters, listen to what Fire Lieutenant Putz, the first officer on the scene, tells you. That as he parks the fire engine on the street in front of the house with a fire from the back, that he comes forward. There are two cars parked in the driveway, and there on the ground is Mr. Morgan. That he's trying to get up, he's stumbling. He seems to have problems talking. He seems to have, as other officers will tell you, a diminished consciousness that can be consistent with smoke inhalation, but more likely consistent with symptoms of being concussed. And when they ask Mr. Morgan, is there someone in the house? And he points to the garage, and he gives the officer the garage door opener, which had been in the car in the driveway. And the officer will tell you that he took the garage door opener and tried to open the garage, and it was malfunctioning. In the end, Fire Officer Russell had to pull the door open where they could find Ms. Welch. And again, pay attention to the details of the testimony. Ms. Welch is lying on her back with her head several feet away from the garage door itself, her feet towards the door into the house, where smoke is starting to come through, and perhaps, depending on the description of the fire officers, some of them saying flames from the main part of the house. But her orientation is facing back to that door, that she sustained, that there is blood pooling about her head there in the garage. And it appears that she is burned and doesn't have a top on. And they take her out of the house. And you'll hear the officer say, about her, there's an odor of gas. And they'll find gas on her clothing. but there'll be no evidence of gas on Mr. Morgan's clothing. And no one from Officer Putz or Lieutenant Putz, who deals with them at first, Fire Officer Fredrickson, there is no odor of gas. There is no evidence of gas on Mr. Morgan. You'll hear that at the hospital, Mr. Morgan's treated for concussion and smoke inhalation. That police detectives come to talk to him at the hospital. And although he still seems confused, disoriented at times, he talks with them and tells them information that will be supported by his mother. That on that weekend that he had Kylie, that he got her on Friday, that he had to work at Bowen, that they had spent the night before at his mother's, that he had been sick, that in fact he had left Kylie at his mother's with the intent that he would come back from work, pick her up, and go back to the house to give her to Brenda at 7 o'clock on Sunday evening. But when he came home, he was ill, he was nauseous, he went back in the house, showered, and fell asleep in front of the TV, upstairs. The detectives will tell you, well, he told them that the next thing he recalls is being struck in the head. Once or twice. And he may have been knocked out. He remembers coming to. He remembers going to the stair to go down. There's a light. There's a fire. And Brenda is on fire. That the top of her body is burning. That he tries to help her take off her top. That he tells him that he tries to help her put out the fire on her hair. And he tries to get her with him out of that house. And then he crawls outside, thinking she's following, and she's not there. And the door is closed, and he hears noise in the garage, and he goes to get the garage door opener, and it doesn't open, and he collapses. And there are efforts to deal with getting water on the house, but basically what you're going to hear is what he told the officers, that something happened in his house. He was struck. That Brenda, yes, who didn't have keys to the house, but had her own garage door openers, that he himself wouldn't recall whether the garage door had been left open or closed when he came into the house, because he wasn't intending to be there all that long before picking up Kylie. That Brenda was in his house and she was on fire. That there are two people we know who were in that house. And you'll hear that Mr. Morgan has been consistent in the time since this. He doesn't know exactly what happened, but he knows he didn't do this. he didn't strike her, and he didn't set his house on fire. And the other person who was there, who can answer those questions, can't. That after her time in the hospital, when she came through, that there simply isn't a memory of what happened, of who did what to her, of how she wound up in the garage, of how she wound up on fire. But listen carefully, because the state wants to tell you not just that it's arson, which their expert doesn't support, where gas is not found, where there is no gas can in the house, but that they want to tell you that it's arson set by Mr. Morgan when there's no evidence of gas on his person and no evidence of a means of distributing gas on Brenda or the house found anywhere. And they want to tell you that the person who's gone through the divorce, who's gone through the relationship with his child, who's paid the money from his retirement when notified what he has to do, is over an extra $500 going to kill somebody and burn his house down. And then, because somehow it's his intent to kill her, is going to quickly say, the garage, here's the garage door opener. I think Brenda might be inside. Ladies and gentlemen, Ms. Welch's testimony and Ms. Welch's condition are tragic. But don't let that be a substitute for evidence or proof. I urge you to do not join the state in some rush to judgment. Listen carefully to what these witnesses testify. Pay attention to them on cross-exam as well as direct exam. And as you listen to it, bear in mind their burden. Because if you do, at the end of all of this testimony, I will get back and ask you to return the only verdict supported by the lack of evidence in this case. Verdicts of not guilty. Thanks.
All right, ladies and gentlemen, that concludes then the opening statement of the parties. We'll now move on to the presentation of the evidence portion of the trial 2.
Which I think will go much faster if we can just take, we need to put one thing on the record as far as technology goes, and we can just put the witnesses on. It would be better to do that rather than have to take a break in the middle. Is that okay? It'd take like 2 minutes.
Are you telling me you want to
take a brief
set
recess?
the jury up for a break?
Just for a very quick break.
All right, folks, your notebooks, please take them in the back with you. Do this for me, though. Take the top cover and close it. And make sure no one has access to it and read it, okay? We'll come and get you as quickly as possible. We'll be in recess.
All right.
So, Judge,
On the
there.
record? On the record?
Yes, please. There are 2 videos that are going to be played through 2 different witnesses, firefighter Jason Turner, as well as Aaron Campbell, who is a neighbor. There are some statements that are made on there by both of them Ms. Silvovitz alerted me that she would be objecting to those statements as being hearsay. I think that properly what should happen is we should play the video without sound, and I'll do that. Just want to make Your Honor aware that once they get admitted, putting it back to the jury, we need to make sure that it gets played without sound. We'll work that out through the law court. I just wanted to put that on the record.
They're going to admit videos of these two witnesses can be returned without any audio?
Right. The audio is, I think it's
I wouldn't know that. That would normally be determined when we do motions in limine, which occurred last week or the week before, but this issue wasn't brought up. What's the defense position?
Your Honor, the defense position, if that's correct, I spoke to Mr. Langman earlier today, and I indicated that I'd be objecting just to the audio portion. I believe that is hearsay, and he does agree with me, so we will not be playing it with the audio on. Otherwise, I would be objecting to the state place provides the proper foundation.
And does the state have these, are they on discs?
They are, yes.
Does the state have discs available with no audio?
No,
The state will make discs with no audio.
Okay.
That it will substitute at a later date on the record. But at this point, I will allow this particular tape then to be admitted, understanding we won't play the audio.
Fair enough.
For legal reasons.
I think we're ready whenever you want to.